Thank you all for tuning in to today's live stream on LinkedIn and YouTube. Thank you all for joining us this afternoon. I am joined by my colleagues Rita Ambrosetti, Peter Bade, and Ryan Harris. And they're going to talk more about the recent proclamation from President Trump. As you may know, over on Friday evening, I should say, the president signed a proclamation restricting H-1B entry, and the proclamation posed a $100,000 fee on H-1B visa petitions for foreign workers outside the U.S. There has been a lot of work going on since Friday evening. Big shout out to Rita, Peter, Ryan, and their colleagues at Corporate Immigration Partners and the team at Envoy Global to kind of decipher that proclamation and learn more about it. And we wanted to use today's session to bring that information and any additional insights and updates to our audience. So in just a few seconds, I'm going to hand it off to them to drive the conversation to our attendees. Thank you so much for joining us. If you do have a question for Rita, Ryan, or Peter, please go ahead and put it in the comment section or the live chat section wherever you may be watching. Please note, though, as always, this live stream is not legal advice. And if you do have a question, please avoid any case-specific, company-specific matters. We cannot address those on this live stream. And as always, this is being recorded, and the recorded version will be posted to the Envoy Global YouTube channel as soon as we get that edited, typically within a day or so. And with that, I'm going to turn it over to Ryan Harris to take it from there.
Thank you very much, Eric. We did a short burst of this type of presentation on Saturday over the weekend that included some pretty draconian travel advice. This is our update to that as we have learned more. But to recap, on Friday, the president issued a proclamation that was issued without any prior notice that did a number of things with respect to immigration, including the $1 million gold card, and some other provisions that we will touch upon. But really what we're focused on here today are these H-1B provisions, including the $100,000 fee for petitions and the restrictions on reentry of H-1B workers unless they have a receipt of payment of that fee. When the order came out on Friday, the proclamation was written and remains so, we'll point out today, very broadly worded to include H-1B workers that the administration now appears not to be targeting in the enforcement of this measure. So that is relatively good news, but there are still some unanswered questions. Following Friday's announcement, travel chaos ensued. I'm sure you've all read about this in the press. And if you have H-1B, if your work touches that visa status, you saw the chaos that was involved. We, as attorneys, were frantically reaching out to employees, telling them either not to leave the U.S. if they were on their way to an airport or if they had just arrived in a foreign destination to try to get back here before midnight Saturday night, because it appeared just by the plain language of the order that they would be barred from entry unless they could show that this new extraordinary $100,000 fee had been paid. So thankfully, on Saturday afternoon, more guidance followed in multiple forms. This included tweets from White House officials on X primarily. There was a USCIS policy memorandum that was issued by the new recently Senate-confirmed director of the USCIS, which is the Immigration Service. And on Monday, the government released a further set of FAQs on the order, and all of which, when you read that all together, has thankfully clarified our understanding on, for now, the scope of the proclamation, and it provided at least some reassurance that existing H-1B workers who are in the midst of international travel would not get suddenly trapped outside our borders. Sure enough, on Sunday, we did have folks arrive at U.S. airports with their H-1B visas. They were admitted, pretty business as usual. We have had H-1B clients go forward with visa interviews at U.S. consulates since then, and they have been able to get visas. So today, we want to just sort of take a breath, go over what we know at the present moment and what questions from a technical standpoint really still remain open for now. We know a lot of you have questions about how this is going to impact programs and your own visa status going forward. So Peter and Rita are going to help me sort of sort through all of that. Before we dive into the details, a big grain of salt for everyone. We all expect lawsuits to be filed imminently, perhaps as soon as tomorrow, almost certainly this week. So it is entirely possible that a court on an emergency a motion could enjoin or order the pause and enforcement of the proclamation. We saw a parallel with this on the birthright citizenship executive order that was issued just after inauguration, right? The administration said individuals born here, there may be limits on who would be considered citizens depending on the parent's visa status. That exists still today as a presidential proclamation, but it is on hold in the courts, and we could see something similar happen here while litigation proceeds. So, with all that in mind, that things could change, on a dime this week or next week. Peter, I will turn to you for guidance on who do we know is exempted right now from the proclamation and from the new fee.
Well, thanks, Ryan. Thank you for that. And we did get some additional clarification over the weekend, fortunately, from USCIS as well as follow-up FAQs. I think there's still a lot, though, of gray area that I think we, agree as attorneys and other attorneys I've spoken to in terms of what is and who is not covered and who is covered by this new fee. I think we know with probably 99% certainty or fairly certain that the following H-1B categories would be exempt from the $100,000 fee just based on sort of the plain language of the proclamation as well as the subsequent clarified memos and documents released over the weekends. One category I'll say is H-1B holders with existing H-1B visa stamps are not impacted by the $100,000 fee. As you mentioned, we had evidence of clients traveling Sunday over the weekend, able to get into the US on their existing H-1B stamp without any issue, without having to pony up $100,000. The other category that seems pretty clear based on the subsequent documents after the proclamation is H-1B petitions submitted before that September 21st deadline. So submitted before that 12:01 a.m. Eastern Time, September 21st deadline. Those petitions are not impacted by this fee. And so if you have an approved petition that was filed before September 21st and it's been approved and you're going for H-1B visa stamping at the consulate, current guidance suggests that you should still be able to go to that stamping appointment without having to worry about being subject to that $100,000 fee. The subsequent memorandum and FAQs also explicitly state that H-1B renewals are not impacted. So even if your H-1B renewal was filed or is going to be filed after September 21st, that should not be impacted. Now, question is, the order and the subsequent documents do not explicitly define what is a renewal. I think looking at the plain language of what's been released, we can all rest assured or have some assurance that your run-of-the-mill H-1B extension for the same employer, same employee, same position, same worksite, that type of vanilla extension should not be impacted. So if that type of extension is filed today or moving forward, that petition should not be subject to that $100,000 filing fee, and folks should be able to go for H-1B stamping based on such a petition without having to worry about that fee impacting their case. Now, it's not clear if a renewal would also include the following types of petitions, and I'll just explain the ones that are most common. H-1B transfers, or if you have an H-1B employee that is going to change from one H-1B employer to another H-1B employer, is still a gray area, I think, as to whether that type of case will be impacted by the $100,000 filing fee. The other type of H-1B petition would be an H-1B amendment. So if there's a material change in the H-1B position, such that the employee is changing work sites or changing the role, and that typically would require an amendment, filing those types of petitions after the 21st potentially could still be subject to that $100,000 filing fee. And the last category I'll say is H-1B change of status petition. So if you have an employee in a different status, L1, TN, F1, and you're filing a petition to change from that category to H-1B, which would also include potentially this year's upcoming cap for fiscal year 27, those potentially are also going to be subject to the $100,000 fee. Again, it's not clear as to whether that would constitute a renewal under the language as we know it. And so I think another point I'll just raise before I pause is I think there's still some discussion about whether this $100,000 fee would attach at the time of filing said petition, or whether that would apply at the time of international travel. In other words, does international travel trigger that $100,000 fee payment, Or will USCIS come out with a system or some process to ask the petitioner, hey, you need to also submit this $100,000 fee check now that you're filing an H-1B transfer, for example. So I'll pause there, Ryan. And I think that kind of covers some of what's going on with that.
Thank you for that rundown, Peter. I think probably safe to say then, if your case falls into one of these, what are for now potentially gray areas, the H-1B amendment for a job change, an H-1B transfer for a change of employer, or if you're changing your status from one status or back to H-1B, for instance, if you change jobs and became on a B visa or an H-4 visa and you're going back to H-1B. If you're in that sort of more ambiguous set of cases, fair to say you should probably be checking with an attorney and really going over the specifics of your case before you depart the U.S. for any further international travel until we know more. Is that fair?
Yeah, definitely with your attorney as well as your HRBPs or your human resource global professionals as well. So yes.
Right. Thank you for that again. So it sounds like cases, even if they can be filed, and we think many of these will be filed and reseated and potentially decided right now, international travel remains a big question. So if you're not in the sort of straight up, like Peter said, plain vanilla extension with the same employer, make sure you're checking in with your resident experts before you finalize any travel plans outside of the U.S.
I
So
agree.
that's what we know as best as we can know it. Rita, that still leaves some big questions. What are those that are top of mind for you right now?
Yeah, thanks, Ryan. I think I get the part where I tell you all of the questions we're not going to be able to answer. So it's kind of the short straw I drew here, but also important for you all to know what is still a question mark, because that is where we can run into the biggest issues. So I'll start off with kind of where Peter left off, which is the payment of this fee. Not only do we not know if it is triggered at the time of filing or at the time of reentry, but how is this fee to be paid? If you are working in the immigration world, you probably know that in the next month or so, we're going to be transitioning from checks to debit card payments. So having to do that when we file a petition for 100 grand, if you're filing multiple petitions, that's certainly a logistical question as well. If it's at your visa stamping appointment and if the employer is required to pay this, how is that handled by the individual? Who are these checks being paid out to? All of those minutia still to be seen. So I think that begs the question of, or the concern rather, if you are in one of the affected cases that we do think will be impacted, which we'll talk about shortly, we are not able to exactly tell you how to make that fee payment right now. So just something to keep in mind, that even from a practical perspective, even if we're able to identify whether your case is impacted or not, there's still questions as to how to proceed here. Another big question that's probably of great interest if you are in one of the impacted categories is the proclamation did carve out a national interest exception. So, who qualifies for this national interest exception? I think is a big question. The proclamation indicates that there's kind of three ways that you can fall into the national interest exception. You, as an individual, are worthy of a national interest exception. Your company that you work for is worthy of the national interest exemption, or your entire industry deserves a national interest exemption. What the proclamation does not tell us is kind of what parameters, what factors are they looking at in order to make that determination. I think we can broadly assess that it would be similar to other national interest exemptions that we have currently in immigration, but that's fluid and that changes very, very frequently, and the standards for those change very frequently. So I think this is certainly an area where we're looking for more development and more information to be able to advise whether it even makes sense trying to go for one of these national interest exemptions, not even to mention like whether you have a good shot at it. And so the other fee related question is, what does a one time fee mean? Certain guidance that we've gotten seems to indicate it's per petition per employee. Certain other guidance seems to indicate it could be per company, perhaps per year. Obviously, we'd be looking at two very different figures. If you're filing 100 H-1B cases a year, that means you can be looking from 100,000 to 10 million, if my math is right, which is a pretty big difference, and certainly important to know for purposes of business planning, especially as we approach, budget season and trying to figure out who's going to go in next year's cap lottery, and all of that really fun business stuff that we all have to do. That is the other question that we're looking for clarification on. Peter also mentioned a few cases that we are pretty sure are not impacted. And I guess this is the one thing that maybe is a little bit more clear in terms of the types of cases we are pretty confident will be impacted. And those are cases that, as immigration attorneys, we're pretty confident should not be classified as renewals. That includes cap cases for next year. I think this is the biggest category that there's pretty much agreement on. This will impact cap cases. The tweet from the press secretary explicitly mentioned that this proclamation was intended to impact the next year's lottery. So, especially for those out of country cases for next year, probably also the change of status cases, but that maybe still has a few more question marks. We do expect those H-1B petitions to be impacted by this fee and require this $100,000 filing fee. And the other category are other change of statuses for individuals who did not previously hold H-1B. So along with cap cases, that could be from cap exempt entities. So universities who are hiring, professors who've been on F1s, J1s with waivers, whatever it might be, who are able to file change of statuses this time of year. For individuals who did not previously hold an H-1B, that's pretty confidently not an H-1B renewal. Seems like it should be subject to this fee. So I think as we have filed cases in the past few days and cases filed on Friday, we're looking to use that data to be able to kind of identify if our theories are correct, and based on what we see in terms of receipts. So I think that's one trigger. If cases are receipted, we can kind of feel like, okay, maybe the fee wasn't required with the petition, but there could always be an RFE. So I think we're all looking to the next few weeks of case processing to help us understand and answer these questions a little bit better to be able to provide some clear guidance.
Thanks for that, Rita. I did observe an exchange with a reporter and administration official in the last couple of days where, for instance, healthcare workers at hospitals were asked about as one of these nonprofit cap exempt employers and whether or not they were going to be wrapped up into the proclamation. And the response was, well, they can potentially apply for one of these national interest waivers. Again, we don't know how to apply for the national interest waiver yet. We don't know what we're supposed to say to get one or what we need to show in terms of the evidence to get one. So the administration is perhaps recognizing in that vein that they've cast a pretty wide net that they may need to pull back. Exactly how that proceeds sort of remains to be seen for now. So Rita and Peter, with that rundown, how are your clients reacting so far?
I can just start it off. They're trying to figure out, they're scrambling and trying to figure out what to do. I'll give you an example, real life example. I had a client today. We were prepared to file an H-1B transfer. They are holding off on that H-1B transfer right now just because they are not sure if they're going to be subject to that $100,000 fee. And so they need to talk to their stakeholders to see, if they are subject to that. Is that something they want to pay? Is that something that this particular candidate is worthy of the company doing? And so they are having serious conversations about transfers and looking at those offers they extended and potentially maybe even reneging such offers. So that's one real world example. Another example, I had a call with a client today who's budgeting, as Rita mentioned, for H-1B cap season. And we are anticipating that this fee would impact this coming cap season. And so trying to figure out, is this something we can do? Is this something our company can afford? Would it make more sense if we were to just park these foreign nationals offshore, Canada, Mexico, Europe? Is that a better, maybe cheaper, easier option for them? So these are the types of conversations I'm hearing that I'm engaging in. And I'm pretty sure a lot of folks in our audience, HR professionals, employees, are having these similar conversations as well.
Thanks for that, Peter. And again, it's entirely possible on the H-1B transfer petition question that these are considered renewals, that the administration would thus exempt from the fee. Again, we're still waiting on further word on that. Certainly test cases have been filed this week, and so we'll get further clarity as USCIS receipts and acts on those cases. But very much a wait and see mode and very much a open question on whether, even if you can get that case through, whether travel is recommended. So Rita, what are you saying to your clients about travel?
That's a great point. Most of my clients are not necessarily withholding case filings right now, but they've certainly ratcheted up their warnings to their employees about traveling and potential consequences. Other than individuals who had approvals before 921, it's very much like, hey, please limit your travel. Even if we don't think you are impacted by this, we saw how quickly this came about and the inability to then pivot and change strategy. Like if you are stuck outside of the US, then that's a problem for you personally, for us from a business perspective. So that's where I've seen my clients be more careful on kind of tweaking how their travel advice has been, which something we've been doing pretty regularly this year throughout various developments, and just letting people know, like, hey, there's a bigger risk if you travel now, even if everything looks good today, it may not be good tomorrow. So having folks keep that in mind and making sure they're mindful about traveling and understanding all the possible consequences.
Proceed with caution. And yeah, a fair point that even if we feel confident that today, with the guidance and what we see from the proclamation is what we understand it to be, which means travel can be okay, it is entirely possible this proclamation gets rescinded, reissued in a different form, revised in some way. And as we saw due to Friday's events, they can do that with very little notice, right? So there could be little time to react. And so just keep that in mind as you're assessing the sort of essentialness of the travel that you're planning. So to round up a little bit on some of the other kind of miscellaneous provisions that do relate to H-1B that were in the proclamation, I guess for the gold card issue, I will just comment briefly because I got several questions from H-1B workers on this, is that the Commerce Secretary, Lutnick, did make a televised comment that the gold card is expected to, in some brief period of time, change the entire availability of employment-based green card pathways that are available. We do not expect that to be an immediate thing. These pathways are written into statute and we think would take an act of Congress to revise those further. That's not to say the administration could not try something more extreme in that range, but there is no present understood official announcement that there is any sort of doing away with green card paths that exist now. So if you're on a perm, if you're getting ready to file an adjustment of status due to the movement and the visa bulletins, I would say don't worry at the present moment that you will not be able to continue down that path. Those pathways still remain open, notwithstanding his comments. On the wage levels, the proclamation asked the Department of Labor, ordered the Department of Labor rather, to revise wage levels upward. There was talk of upskilling the H-1B program in the latest guidance that was released. And so we do anticipate that something we saw under the prior Trump administration, that we could have increase in the wage levels that are required under the DOL, Department of Labor wage data, when a H-1B case is filed. So that remains to be seen what will happen in the movement of those wage levels. Alternative wage surveys could be important and remain a legal pathway to deal with the strategies of those cases. Keep in mind that the proclamation also sounded a note of caution about the scrutiny that B1, this is sort of business tourist travel, that would be permitted. So I suggest to us that they will be on the lookout for anyone trying to end run the $100,000 rule, that if it may apply in your case, by making an entry under a different visa type, like a business visitor visa, and then attempting to change your status within the U.S. I would say if you're considering such a move, looking down the road, thinking there may be impact, you make sure you're working with an attorney to strategize all the various moves that it takes to activate status. Finally, I'll hit upon the explanation in the proclamation about weighting of higher wages in the H-1B lottery. And instead of making this more of a random roll of the dice type of selection, that higher wages would have additional chances to be selected in the cap. Well, in line with that, today, the administration did release a proposed regulation. Public comments can start going in on that regulation, I believe, as of tomorrow, with a 30-day period of window for those comments to be submitted. It does appear that the administration is at least targeting the 2026 cap lottery for this idea that you would weight the averages. I think remains to be seen whether courts will get involved, whether the regulatory process will play out that quickly, and whether the technical engineering can take place in order to update the government's portal, but we could be dealing with something on the pretty drastic difference on the lottery as early as this coming spring. More to be seen on that. We're all analyzing the order as it was just released this morning, and so we'll have more information on that. I'd say we will have another webinar separate from this today on the notes of increased enforcement and the Project Firewall announcement out from the Department of Labor that there could be increased investigations of employers' compliance with the H-1B rules. So definitely much more to come from us on that. So I know that was a lot to cover. Eric, just checking in with you to see if we had any live questions come in, or if we want to allow for that.
Hey, Ryan. Yes, we have had a lot of questions coming in. Do you all have a preference on how we go about addressing these questions? You want me to read them out loud? I've been pasting some of them in the streaming platform's chat. So down for whatever's easiest for the three of you to address.
Okay, I think, yep, I've got them here. So let me, all right. Question is, if someone was selected in the H-1B lottery, I'm assuming this means in the last year, and their petition was approved effective October 1st, 2025, and they travel abroad and return to the U.S. to obtain an H-1B stamp so their status can begin. Peter, do you want to take that one?
Yeah, I think that's probably one of the more certain categories based on the language of the proclamation that is not subject to this fee. It does explicitly call out that any petitions filed before September 21st, 2025 are not subject to that $100,000 fee. Obviously, for this cap season, 100% of those petitions were filed before September 21st. And usually in that situation, your cap case is going to be exempt from that fee. And so you can proceed with visa stamping as you would.
Yeah. And Rita, I'll combine the next two questions that I'm seeing here. Is, do you see the possibility of this impacting green card applications? And do we anticipate any changes to the L1 visa category?
Yeah, I mean, I think nothing in this proclamation other than, the gold card illusions that Ryan mentioned directly address green cards and L1s. But I think if we're looking at trends since January, we've seen TPS be kind of attacked. We've seen limitations on F1s and have more scrutiny on those. Now we're seeing it on H-1Bs. I have no reason to think that there would not be something more explicit on L1s down the line. We have already seen increased scrutiny at certain consulates for the blanket L1s. So I think it's definitely possible. There's nothing concrete at this point, though, that makes us change anything about how we do the L1s, except maybe strategically filing one place or another. But yeah, certainly I think any kind of employment authorization or other immigration status is a potential next victim for action or limitation.
Yeah, and again, just hitting on the lack of notice in the current order, that oftentimes when there's a big change or a change this big coming, there will be some signaling and some rumors, at least, or some chatter that we will get wind of. And I think what you've seen in Friday's proclamation is basically nobody was ready for this, and no one had ever heard of it before. And so sudden changes, may be something we just need to kind of buckle up for. Next question up is that our biggest question is if we have current employees that are on F1, right? They weren't chosen in the lottery next year. We want to make an attempt for them in the coming year for the 2026 lottery. Will that $100,000 apply to us? Right now, it looks like it possibly will for those employees who are outside of the U.S. Now, this is complex and hard to follow because even for those who are inside the U.S., those F1 employees maybe who haven't left and we're filing a change of status petition, maybe that petition gets approved. But under the way we read the order today, international travel could potentially subject them to a reentry ban. So again, even if we can proceed to file, we still need to treat travel as a really separate question with this and really be working with your legal counsel to make sure that you've looked at the specifics of any individual case before you clear that travel. Another question, what strategies would you recommend for a business to effectively communicate this to current F1 students who may have concerns, particularly those who could be included in the next H-1B lottery, in order to provide clarity and reassurance? Say for now, because we do have a little bit of time on this, and Rita, Peter, feel free to jump in on this. I think present day, and this might change next week, is let's wait and see what further guidance is offered and how they bake this into the rules for the new lottery. Anything else you'd add to that?
No, I
I
agree.
agree with. Yeah, I agree with that. I mean, maybe disseminating this recording of this town hall to your employee population, or speaking with your legal counsel to see if there's any town halls that you want to do with them to engage them to sort of put some people at ease if that's possible in this moment. So yeah.
There's a question about whether or not there would be exemptions for particular classes, types of workers, for nursing, physicians, healthcare. Rita, I think that goes to the exceptions that you discussed.
Maybe.
Yeah.
I think like maybe those are technically professions instead of industry or company, but I don't think that precise language is really the name of the game here. So I think that's certainly a possibility.
Next question is how the weighted lottery rulemaking relates to the proclamation, and if good question asked whether if the proclamation is struck down soon, right, will that take down the rulemaking? Not necessarily. The rulemaking is not dependent on the proclamation. It is going through the typical agency rulemaking procedure through the Administrative Procedures Act. So there could be vulnerability to that rule depending on whether it is consistent with the governing law, as whether or not it's a valid exercise of agency authority, whether they can make that change. It would be shocked not to see challenges. I think when this came around in the first Trump administration, there were challenges. It was put on hold, and it eventually died out under a newly elected Biden administration. And so this is kind of a reviving of an idea that was explored back then, but didn't quite get off the ground from a regulatory perspective. But no, the two are not linked in that way, such that if you get an order soon that there's no $100,000 fee, that does not mean that the weighted lottery is going to go away. I'm getting some questions about how to treat new hires that you may be considering who may be subject to these rules, who may be employees that need sponsorship. We're not really able to answer that in this forum. I'd say make sure you're checking with your immigration counsel and your employment counsel on how to treat those hiring decisions for the moment. And then I think finally we are getting to, can we hear more on the, I think the questioner meant to say on OPT considerations. Peter, any impact we're seeing for OPT that's presently issued and valid today?
Nothing at the moment, and the proclamation doesn't address, any impact to OPT specifically, other than, if you're going to enter that F1 student into the lottery next year, as we discussed, that probably is going to be subject or impacted by this $100,000 fee. I am, looking at some of the news articles. There is some, actually, I think there might have been a press release today talking about wanting to limit the duration of status for F1 students in general. So, when you enter as an F1 student, you get the I-94 card, you get that duration of status stay. But I know that the administration is looking to limit that to potentially 4 years, I believe, is what I read, or the expected completion of your F1 program with the school. But the current proclamation and the subsequent guidance we have doesn't explicitly impact OPT, as it were.
Eric, I think that covers the questions that have come in so far. So maybe we'll take the opportunity here to thank everybody for showing up and listening in. I'd say, your legal professionals and your internal mobility teams have been through it over the weekend, and everybody's trying their best to get you the information that we have as best as we understand it. And it is very much a still developing and fluid story. So certainly more to come on all this. I hope you all have found some of this useful and look forward to working with folks in the days ahead to navigate these issues.
Thank you so much, Ryan. And be sure to head to onfoglobal.com for the latest updates from the teams.